Welcome back. New allegations are being made against singer David, who is accused of killing a 14-year-old fan. A preliminary hearing began Tuesday in an LA courtroom. A homicide detective took the stand accusing the artist, whose real name is David Burke, of ordering a body bag, chainsaws, an inflatable pool, and a shovel online just days after the alleged killing. Prosecutors say Burke stabbed her after she threatened to reveal their relationship. The 14-year-old victim's remains were found in September of last year in a car registered to David.
And we do not predict when he is convicted, we will then be seeking the sentence that we are allowed to seek by order of the law, and we will let you know in a future date whether or not that sentence will also include the death penalty.
David has pleaded not guilty. The DA expects a preliminary hearing to last for 4 days.
We're going to bring in our chief legal analyst, Khalif Rhodes, once again to talk about this, a highly publicized case. But when you take all the evidence, if you've been following this, it doesn't look good for that singer. We should note the car that she was found in a junkyard in a Tesla that was registered to the singer. When you're on a defense team with all of this evidence, how are you trying to present your case?
Well, I mean, first of all, let's look at this. This is disturbing. I mean, these allegations, if true, are extremely disturbing. And looking at the preliminary hearing, I looked at all the reports yesterday because there are no cameras there, but in the courtroom. But her parents were right there, feet away from him, watching and looking at all this evidence as it was laid out. This is not a trial, and so, as Julian mentioned, this is the preliminary hearing. The judge is attempting to determine, was there enough probable cause to go forward with him to have a trial? That's what's happening during this. So it's like a mini trial, similar to what our grand jury process here in North Carolina would look like, except for the defense attorney doesn't have any play in our grand jury aspect here. But if it can make it past that stage, then they'll get to the informal arraignment process in California, and they'll be formally arraigned on the charge. When at this stage of the game, you're listening, you're trying to gather and acquire as much information as you can. They would have already turned over some of the discovery. You're probably learning more in real time. You're learning a little bit of the strategy that the prosecutors are going to attempt to use when they're going forward. And so this is an information gathering aspect, while also you're trying to figure out, well, what is your story? There's a number of pieces in this case that, when I look at my cases, specifically when the discovery is dropped on me, I mean, the forensic evidence is a lot, right? You have the officer testifying yesterday about opening the trunk and different limbs being there, you know, and different liquids that he couldn't even describe. I mean, so you're attempting to figure out, well, how do you work around that when you get to trial? And that's going to be a massive uphill battle. The other portion that I could say is the evidence that's out there will be hard to overcome because it's his own data. So we're talking about your Uber rides, right? Your Amazon account, your Postmates account. You order things from Home Depot. I mean, you're getting chainsaws and other things like that. It's not like it's you went in there and borrowed it from someone. It's on your account. So now I'm trying to figure out how you have something for that. Again, working in that room would be hard to try to come up with what a defense will look like.
Khalif, when you talk about a 4-day preliminary hearing, I guess the question that some people may have is, why does it take so long to go through it? Because after we talk about the evidence there, it seems like there should be enough, right, to say, okay, we've seen the evidence, let's go to trial.
Well, I would agree with that you would believe that it would be that simple, but laying the foundation for pieces of evidence to be introduced, right? For that aspect, for you may have a witness come up to the standing officer. Well, it's going to take 5 to 10 minutes for them to talk about their background, to talk about their expertise, and now talk about exactly what they've seen. And now the prosecutor may have 15 to 20 minutes of questioning. Now the defense attorney may have 15 to 20 minutes of questioning. Well, if you got 20 folks like that, you can see why it can take time. So at the very beginning, the judge will say, what's the estimated time? Most of the time, the prosecutor is looking at, well, how many witnesses do I have? How many pieces of evidence do I want to submit and try to get admitted and get published? And so if you got one piece of evidence, you have to establish that evidence. You have to be able to now say, does this person recognize this video, lay that foundation for that to be admitted, and then publish it. So now all these pieces of evidence, if you got 20 pieces, it could take a long time. But if you got hundreds of pieces of evidence, now you got to bring in all these forensic analysis folks that looked at the phones. There are a number of people that will have to come into court. It's not as easy as just putting one person up there and saying, hey, I did this, we found this, let's go to trial. That's why I said you're learning as a defense attorney aspects of the case, because you're going to see a lot of these witnesses testifying to support the prosecutor's case.
Does the defense have their own witnesses during this portion too, but maybe not as many?
They can, but I mean, that would be rare. Most of the time they're listening, because I mean, you have no duty or no burden at this stage to prove anything, just like you wouldn't at the trial level. The goal for the defense attorney is to ensure that you mitigate a lot of things that they're saying, I mean, disconnect them from your client.
Khalif, real quickly, because we're running out of time, what burden do you have to reach in California? Because the attorney did mention the death penalty there. So what would you have to reach in order for a judge to say, okay, this is worth that?
Well, it's not just a level. It's first the judge has to make a determination that we're going to go to trial. Okay. Once they make the determination that we're going to trial, that's going to be at the prosecutor's decision if they're going to seek the death penalty or not. So that's why he mentioned we're not even going to have that conversation yet until we get past this first phase, which is, are we even going to have a trial? Then we can make a determination now, which is different than here in North Carolina. We have a Rule 24 hearing. I guess it wouldn't be different, but this preliminary hearing is something that's more unique to states that are outside of North Carolina.
Gotcha.
All right.
Okay.
Thank you, Khalif.
Queen City News Plus. Just search Queen City News on your smart TV's app store.